All. Today's subcommittee on capital markets and government-sponsored enterprises called to order. Today's hearing is entitled Legislative Proposals to Enhance Capital Formation for Small and Emerging Growth Companies, Part 2. So we welcome all the panelists. Well, we welcome all the panelists who are here. Mr. Miller, Shirley. We will be looking to you shortly for opening comments, or for your testimony, I should say. But before that, as is normal, of course, we will go to opening statements. So at which point I'll yield myself about 6 minutes, I guess, for an opening statement. So good morning, once again, and welcome to today's hearing. Thanks in large part to the Jobs Act of 2013, which was the best year for initial public offering since 2000, with more than 175 IPOs raising more than $40 billion in much-needed growth capital. And at least 80% of these companies qualify as EGCs, emerging growth companies, under the Jobs Act. And while this is a very positive development, we believe that more work needs to be done. For example, according to one small business survey, government regulation and red tapes remain at the very top of the list of the most important problems facing American job creators. Another survey shows that small business demand for private capital continued to outpace access in 2013, while in at least 60% of the respondents found it difficult to raise new external financing. And so, building on the early successes of the Jobs Act, this hearing represents another opportunity, the fifth hearing we've had during this Congress, to explore ways to further reduce unnecessary regulatory burdens and enhance access to capital for small American businesses. Now, while the bills we have considered during this Congress address a variety of capital formation issues, they are designed to target regulatory problems in three overarching areas. Let me go through them. First, some of the bills continue to help small businesses access capitals by going public. We call that pre-IPO. Then some of the bills improve the ability of small companies to access capital and compete after they have gone public. We call them post-IPO. And finally, some of the bills help small businesses attract more investment in the private market. We just call them no IPO. So these three legislative proposals we'll be discussing today fit within the third category I just talked about. And the gentleman from North Carolina down the end here, Mr. McHenry, he has circulated a discussion draft to fix the Senate's burdensome statutory missteps in the crowdfunding title of the Jobs Act by restoring a bipartisan policy authored in this committee last Congress. Mr. McHenry has also offered a discussion draft to modernize the Regulation A section for small companies by updating issuance caps while striking the right balance between preserving state enforcement and lifting burdensome regulation requirements. So the discussion draft also codifies language that effectively and efficiently facilitates liquidity in the secondary trading of what's called restricted securities among sophisticated investors. So I thank Mr. McHenry for his hard work and thoughtful proposals to make the crowdfunding and Reg A provisions of the Jobs Act more cost-effective and efficient options for issuers and the investors alike. Finally, I have circulated a discussion draft to ensure that issuers and investors in certain private offerings under Reg D do not face overly complex and burdensome regulatory obstacles. As you all know, last year the SEC adopted a rule lifting the ban on general solicitation and advertising in private offerings under Rule 506 of Reg D, as mandated by Title II of Jobs Act. Unfortunately, the SEC didn't stop right there. Instead of simply removing the ban and opening up this market to new potential investors, the SEC decided to issue a separate rule proposal not called for by this Congress that would impose a number of new, burdensome regulatory requirements on issuers seeking to use Rule 506, the exemption. The SEC's selective judgment in deciding when and how to follow clear congressional directives and when not to is, of course, disturbing and disconcerting to me. When members of this committee, outside stakeholders, and even other SEC commissioners pleaded with the Commission to issue a more pragmatic rule regarding conflict minerals, the Commission refused, stating, quote, well, if Congress had intended that a mandate be limited, further, we think Congress would have done so explicitly, end quote. Unfortunately, the Commission did not apply this same rationale in a consistent manner when it came to the removal of the ban on general solicitation. As one comment put it, quote, "The Jobs Act on its face does not authorize the Commission to attach new and additional conditions to the use of the exemption. It is not for the Commission to rely on its general rulemaking authority to bring Congress and the President back into line by adding conditions that it believes may enhance investor protection." End quote. However, that is exactly what the Commission did. That the SEC believes it has the authority to alter a clear mandate in the Jobs Act, but not in the Dodd-Frank Act, certainly suggests, as Dan Gallagher from the Commissioner of the SEC said, quote, "In the face of its statutory mandates, the SEC only thinks outside the box and uses its expertise when it means adding regulations, no matter the cost." End quote. Indeed, I believe that many of the additional requirements in the SEC's Reg D proposal will, if ultimately adopted, make Rule 506 a less attractive avenue for small business capital formation and at the same time harm investors' choice. And this, of course, is clearly at odds with the goals, let alone the text, of the Jobs Act. And so my discussion draft would address some of the more burdensome red tapes portions contained in the SEC rule proposal, including, certainly, costly filing requirements and disqualification provisions. Now, before I conclude, I want to be clear on a few points regarding what the discussion draft would not do. It would not remove the SEC's existing Form D filing requirements. It would not remove the SEC's existing requirement that issuers take reasonable steps to verify that investors in Rule 506 offerings are accredited. And it would not reduce the SEC's existing rules requiring disclosure to investors. And it would not limit the SEC's existing authority to prevent and punish fraud and other misconduct under the federal securities laws. So, I believe this discussion draft will ultimately strike the right balance between helping American job creators raise much-needed capital and protecting Americans who invest their hard-earned money in these companies at the same time. So I thank you very much for your attention, and at this point, I yield back, and I yield to Ms. Maloney, gentlelady from New York, 4 minutes for her opening statement.
Thank you, Mr. Chairman, and welcome to all of the witnesses. And I'd like to particularly welcome Ms. Tierney, who's from the great state of New York, and I have the privilege of representing you. Thank you for being here today. The U.S. capital markets are the envy of the world. They offer investors liquidity, transparency, and flexibility. And they offer companies access to capital in the form of a deep pool of investors who stand ready and willing to invest in promising businesses. In short, the U.S. is where companies come to raise money. While the system of securities laws in the United States is complex, the central tension underlying our securities law is very simple. Investors want as much information as possible on the companies they're investing in, and as quickly and as accurately as possible. Often the issuing companies, on the other hand, want to keep as much information as possible about their business practices confidential. Companies also want to spend as little time as possible preparing the disclosures that their investors crave. It is the job of public policy to strike the right balance between these competing desires. But public policy does not run on autopilot. In the securities market, we often entrust the job of properly balancing these competing goals to the regulator, the Securities Exchange Commission. I would like to say in the securities market especially, we need an active and informed regulator to write, enforce, and when appropriate, change the regulations to keep pace with innovation and the market. Of course, the SEC isn't the only securities regulator in the United States, nor should they be. The state securities regulators play a very important role as well. And we have one of those state regulators on our panel today, Mr. Bill Beatty from Washington State. Welcome. State securities regulators are in the best position to provide on-the-ground protection for retail investors who are investing in securities offerings and are too small to merit the SEC's attention, especially given the SEC's lack of resources. The state regulators are also well-positioned to provide investors education to mom and pop retail investors who don't have a fortune to invest, who never worked on Wall Street, and who are most vulnerable to fraud. Sometimes, of course, Congress has decided that it's necessary to preempt state securities laws in order to reduce the compliance burden for companies seeking to raise capital. But I don't think these decisions on preemption should be made on, but I do think that these decisions should be made on a case-by-case basis. Sometimes it will be appropriate to preempt state law, and sometimes it will not. I hope that we can use this opportunity to have a robust discussion about the proper role of state securities regulators so that we can inform our own thinking about how to maintain and improve our country's capital markets. I look forward to the hearing today, and thank you very much, Mr. Chairman.
Thank you, gentlelady. And gentlelady yields back, and we now turn to the Vice Chairman of the committee for a couple of minutes.
Thank you, Mr. Chairman. Mr. Chairman, thank you for holding today's hearing on these three legislative proposals to further enhance capital formation. I also thank our witnesses for being here today. While we've witnessed the successes of the Jobs Act in the 2 years since it was enacted, more still needs to be done, starting with the SEC completing implementation of the Jobs Act. Additionally, Congress and the SEC must expand on those successes and find practical solutions to increase access to capital for small businesses without sacrificing key investor protections. Our security laws are riddled with outdated and burdensome regulations that are hindering small businesses in Virginia's 5th District, our district, from accessing the capital they need to grow. As our markets and the needs of its participants continue to evolve, it is necessary for our regulatory structure to reflect those new realities. Chairman Garrett and McHenry's bills will provide important modifications to key sections of the Jobs Act that enhance the ability of small business and startups to raise capital. For many of the companies that would take advantage of these improvements, the public markets are not a viable option, and they would otherwise face increased costs and complexity to meet their goals. I appreciate this committee's continued focus on ensuring that our small businesses and startups have the ability to access the necessary capital in order to innovate, expand, and create the jobs that we need. I look forward to working with my colleagues to advance these proposals and others that will provide growth and opportunity for our constituents and our communities. I look forward to your testimony, and thank you for your appearance. Thank you, Mr. Chairman. I yield back the balance of my time.
The gentleman yields back. For 4 minutes, Mr. Scott, recognize.
Thank you, Mr. Chairman. First of all, let me say that I agree with both Chairman Garrett and Ranking Member Maloney's very thoughtful and opening statements. However, we've got to look at the big picture. First, we do have to reduce the barriers to capital formation. But most importantly, we got to really identify exactly what these barriers are. Be very truthful about what these barriers are. Then we have to increase opportunities to raise that capital. And then, yes, we must address any regulatory impediments or burdens that make it difficult to raise additional capital. As we know, the Securities and Exchange Commission has a three-part mission. First, it is to protect investors, maintain fair, orderly, and efficient markets, and facilitate capital formation. And nowhere is that needed more than our small businesses. Small businesses are still the heart and the soul of our economy. They produce most of the jobs, especially new jobs. Recently, the Securities and Exchange Commission's Advisory Committee on Small and Emerging Companies put forth a series of recommendations that we and ultimately the Securities and Exchange Commission should provide due consideration, and I believe that this committee will, jointly with the SEC. Now, whether it's allowing for larger size of increments in bids or tick sizes for smaller companies, an option that's currently under consideration by the Securities and Exchange Commission, or more controversial options. Some of us may not initially care for, but we've got to look at the big picture and recognize that we must be open for debate. Like, for example, increasing the size of companies exempted from Sarbanes-Oxley's auditor attestment requirements, or another, exempting smaller companies from shareholder advisory votes. Yes, on executive pay and compensation, if we have that clear evidence that these are impediments to capital formation. Capital formation must be forced. And of course, we've got to look at it with a very Johnsonist eye first. We must also ascertain what significant evidence on small business capital formation exists measuring the impact of the Jobs Act. The Jobs Act is successful. It was signed into law just a little more than a year ago. The fundamental first question is, are we moving too soon? Have we in Congress given enough time to fully implement and evaluate the effects of the Jobs Act before pushing for additional experimental small business capital formation proposals? That's the big picture to me. I think we need to look at that. This is a very serious issue, and our small business community certainly deserves that. And with that, I yield back the balance of my time.
Gentleman yields back. Mr. McHenry for 3 minutes.
Well, I want to thank the chairman for holding this hearing and for his leadership on improving our capital markets. And 3 years ago, this committee undertook a bipartisan committed effort to update our outdated securities laws. It created new partnerships on this committee and resulted in significant bipartisan votes. With a little luck, our committee's solidarity led to the advancement and passage of the Jobs Act, which President Obama signed into law just over 2 years ago. The act was arguably the most significant piece of legislation in the last Congress. Congresswoman Maloney and I authored Title III of the Jobs Act, also known as the Equity Crowdfunding Title. What motivated us was a pledge to cut red tape, as well as strengthen and ensure investor protections, and allow startups to employ the Internet as a means to solicit small equity investments from everyday investors without triggering costly SEC registration. Our original bill, passed by voice vote in this committee and by over 400 votes on the House floor, was the only title within the Jobs Act to get the full and public endorsement from President Obama. That's significant. But then the Senate happened. An ill-advised and 11th-hour move resulted in the Senate striking a broadly supported title of the Jobs Act that Congresswoman Maloney and I authored, and hastily substituting an arduous amendment that neutered the promise of equity crowdfunding. After patiently waiting for the Commission to reveal a crowdfunding rule proposal, and academics and market leaders submitting hundreds of comments, it is now clear that the current statute has failed. But that does not mean that equity crowdfunding is destined to failure. Today's equity crowdfunding discussion draft not only restores what Carolyn Maloney and I started 3 years ago. This committee's commitment to democratizing capital is front and center in that, but it also incorporates thoughtful suggestions by commenters who aspire to strengthen the vitality of equity crowdfunding. Separately, the discussion draft on Regulation A and the resale of restricted securities simply codifies the spirited intent of Title IV of the Jobs Act, reviving an exemption to connect small enterprises and everyday investors. Furthermore, the draft amendment to the 33 Act it also codifies policy that efficiently cultivates liquidity in secondary trading of restricted securities among sophisticated investors. So we do a lot for the everyday investor and a lot for the more sophisticated investors. I believe democratizing finance and extending access to America's startups are not partisan ideas. In fact, they're anything but. But what motivates each member of this committee is to ensure that we have a bipartisan achievement that helps entrepreneurs and everyday investors. That's what this is all about. Thank you, Mr. Chairman.
I thank the gentleman. I'm going to thank the gentleman for his work on these bills. The gentleman yields back. And for the last word, 2 minutes.
Thank you, Mr. Chair, very much, and Ranking Member Maloney. It is my privilege, while not a member of this subcommittee, however, to welcome on its behalf Mr. Bill Beatty from Washington State and a constituent of mine. Mr. Beatty is, in fact, the Securities Administrator for the Washington State Department of Financial Institutions. More importantly, for purposes of today's discussion, he is the President of the North American Securities Administrators Association, and we're so very, very pleased, honored, and grateful that you would come all the way across country, a trip I know well, to share your insights. Mr. Beatty is a graduate of the University of Puget Sound and Seattle University School of Law. There probably is literally nobody in the United States with more expertise in securities law, and I'm looking forward for you to receive information from him about how it is state securities administrators can play a role in protecting investors, while at the same time helping capital markets perform as efficiently as is possible. Thank you very much for allowing me to stop by, Mr. Chairman. Mr. Beatty, welcome to Washington, D.C.
Okay, thank you. The gentleman yields back. And now we turn to the panel. Again, we thank all the members of the panel, regardless of how far across the country they've flown, for being with us. And but thank you for flying so far. And so we will, for those of you who have not testified before this committee, just a few simple reminders. The little machine in front of you shows your time, 5 minutes, green 1 minute on the yellow, and then red you're supposed to be, well, yellow you're supposed to be summing up, and then red you're supposed to be done. Also, we also always remind you to pull the microphone closer than it looks like now for each one of you, because it doesn't pick up that well, so when you do speak, pull it close. And finally, that you're going to be recognized for 5 minutes. Will you recognize to give a summation of your remarks? Your entire remarks that you've prepared have already been put into the record. So with that said, we turn to our first witness, Mr. Miller, co-founder of Fundrise. Mr. Miller, welcome, and you are recognized for 5 minutes. You haven't pushed the button. You got it.
Chairman Garrett, Ranking Member Maloney, members of the subcommittee. My name is Ben Miller. I'm the co-founder of Rise Companies Corporation, which owns and operates Fundrise, a real estate crowdfunding platform based here in Washington, D.C. I'm honored to be here to testify on my experience using Regulation A to crowdfund the development of local real estate here in the District of Columbia. Let me spend a moment on my background so you understand how I came to run Fundrise, one of the only companies in the country currently raising equity online from the public, both from accredited and unaccredited investors in Washington, D.C., Maryland, and Virginia, prior to the implementation of Title III of the Jobs Act. Before starting Fundrise, I ran a real estate company. In that capacity, I led the acquisition and development of more than 2 million square feet of property, such as Gallery Place on 7th and H Street Northwest, a 750,000 square foot mixed-use development. As a real estate entrepreneur, I partnered with some of the largest institutional investment companies in the country, such as MassMutual, Angelo Gordon, and the AFL-CIO. So I understand what it means to raise debt and equity in the capital markets. But one day we asked ourselves, why are we raising money from institutions which have no real relationship with the places in which we are investing? What if we raise the money from the people who live there, who care, who are part of the neighborhood? So that's what we're doing, and explains why I'm sitting here. We've been raising real investment in increments as affordable as $100 per share from the people who live near our real estate projects. Since the Jobs Act did not exist when we started our endeavor, we had to work within the existing regulatory framework. And thanks to our outstanding and expensive legal team, we found a way through Regulation A. Our initial Regulation A filings with the Securities and Exchange Commission totaled more than 350 pages, but eventually allowed us to sell equity online at $100 per share to the local public. To my knowledge, over the past 2 years, we're the only ones who have successfully qualified more than one Regulation A offering, having climbed the regulatory mountain associated with Regulation A no less than 3 times. Each Regulation A offering was a serious undertaking, one that did not generally get easier over time. For example, despite many similarities among our prior offerings, our third regulation offering took us more than 6 months to get through the regulators, which included hundreds of pounds of physical paper, actually approximately 25 pounds per filing, 8 separate attorneys, more than $50,000 in legal fees, and 2 sets of reviewed accounting financial statements. All of this to raise $350,000 from the residents of only 3 states. Yet we view ourselves as fortunate. Our local regulators in D.C., Virginia, and Maryland understood that we were working to build local places and create a new capital source for local job development, and know that less inclined regulators could have and potentially would have made it impossible for us to move forward. In our experience, the likelihood that a Regulation A offering becomes effective is primarily dependent upon the jurisdictions in which the offering has to be registered. Given the great uncertainty that places upon an endeavor that requires tens of thousands of dollars and many months to begin, without regard to whether the issuer will actually be successful in its Regulation A offering. We support any proposal that lessens the regulatory burden of Regulation A offerings while simultaneously increasing the regulatory certainty faced by small businesses seeking to raise capital. In addition, like many in the industry, we reviewed the proposed Regulation A+, and we support the exclusion of investors in Regulation A+ offerings from the number of holders of record counted under Section 12G of the Exchange Act. We do not believe that, given the ongoing reporting requirements already proposed in Regulation A+, requiring small issuers to become subject to the onerous and expensive reporting requirements of the Exchange Act serves either investors or the small business community. However, we would note that we found the wording contained in the draft bill to be slightly confusing and asked the subcommittee to consider whether there are clearer and simpler ways to accomplish the goal. We at Fundrise take very seriously our ongoing mission to open up real estate investment to the general population beyond institutional and accredited investors that have predominantly held sway in the market. We believe that the proposals contained in these bills provide substantial positive steps towards democratizing real estate investment and encourage the subcommittee to consider each of these proposals seriously. I'm happy to take any questions that you may have at this time. Thank you.
And I thank you, Mr. Miller. Gentleman yields back. Next, Ms. Tierney, Executive VP and General Counsel of Second Market. Welcome, and you are recognized for 5 minutes. Oh, you got to push the little button.
And pull it forward.
And pull forward, yeah, so I can hear you.
Good morning, Chairman Garrett.
Thank you.
Ranking Member Maloney, and members of the committee. My name is Anne-Marie Tierney, and I'm the General Counsel of Second Market. I'm very grateful to be able to testify this morning. I've been in the securities industry for almost 25 years, and have worked in a number of legal roles, including at the SEC, the law firm of Skadden Arps, and NYC Euronext, before joining Second Market in 2010. For those of you not familiar with our company, Second Market was founded in New York City in 2004. We're a registered broker-dealer and a leading provider of services to facilitate transactions of private company stock. We've also advocated for regulatory change to help private companies raise capital and facilitate job creation, including changes to the 500 shareholder threshold and the elimination of the ban on general solicitation and advertising included in the Jobs Act. Today, I'd like to express our support for the adoption of proposed Section 4A7 set out in Section 5 of the draft bill to amend the securities laws to improve the small business capital formation provisions. I will also share insights on how the current regulatory framework for resales of private company shares imposes significant and unnecessary challenges to private company capital formation and job growth. Under current laws, the only federally codified safe harbor for resales of private shares is Rule 144. The safe harbor, however, is only available to shareholders who are not affiliates of the company and have held their common or preferred stock for at least 12 months. This means that Rule 144 is not available to private company founders, many angel investors, and officers and directors. It is also unavailable to employees who own equity in the form of stock options. Instead, resales by these types of shareholders occur in reliance on a long-standing legal construct referred to as 4A1.5, which is a mouthful, and are subject to state blue sky regulations that must be satisfied in every state where potential buyers are located. I'd like to provide 2 examples of the challenges that this legal framework poses for private companies. In 2012, Second Market expanded our business to include private community banks. These banks were looking to provide liquidity to their employees and shareholders. The benefits of that were obvious. Providing community bank shareholders a clear path to liquidity once or twice a year made it easier for the bank to raise capital and attract talented employees. And greater access to capital meant more loans to the community and job creation. The reality, however, is that almost every state other than New York State prohibits broker-dealers from reaching out to their accredited investor clients to identify potential interest in private company stock. a prohibition inconsistent with SEC and FINRA rules, which allow broker-dealers to discuss opportunities with clients if there is a pre-existing relationship. This restriction ultimately made it impossible for us to create successful liquidity events for these important businesses. In addition, the other exemptions that are available for resales in the state level are interpreted inconsistently across the states and create a patchwork of regulation that's almost impossible to navigate even for a registered broker-dealer. It's almost as though you're trying to put together a Rubik's Cube and you're missing one piece. It's almost impossible to make it work across multiple states. This inconsistent legal framework also creates significant challenges for private company employees seeking to exercise their options and monetize a significant component of equity compensation. Every option has an exercise price that must be paid by the employee in order to convert the option to common stock. In addition, option exercise creates an income tax event for the employee. Since most rank and file employees of private companies don't have sufficient funds to pay these costs out of pocket, they often need to simultaneously sell a portion of the common stock underlying their options to cover these costs. So they can't satisfy any hold period, much less a 12-month hold period. As in the case of community banks, state law restrictions make it extremely difficult for employees or broker-dealers acting on their behalf to find buyers for these shares. As a result, a significant amount of equity of employee options expire every year, resulting in a real economic loss for private company employees. In my view, proposed Section 4A7 merely codifies a long-standing federal construct applicable to resales of private company securities by shareholders who cannot rely on Rule 144. In addition, I would note that all of the securities eligible to be resold under proposed Section 4A7 are securities that were originally issued to shareholders in transactions that were themselves exempt from federal and state registration, such as Rule 506 and Rule 701, which provides an exemption for shares issued under certain equity compensation plans. The proposed legislation includes, I'd like to note that the proposed legislation also includes important protections, such as that the shares may only be resold to accredited investors and remain restricted after the resale. The proposed legislation also requires verification of accreditation if general solicitation or advertisement is utilized. Under the current outdated and inconsistent regulatory regime, founders, large angel investors, officers, and a large percentage of startup employees are put at a legal and economic disadvantage in a post-Jobs Act world. In light of the fact that startups are estimated to create an average of 3 million new jobs annually, it's essential that the federal and state regulatory framework continue to evolve to create an environment in which startups can flourish. I'd also like us, and providing founders and angel investors greater facility to sell their shares means that more capital will become available to start new companies and create more jobs. I'd also like to note that we agree strongly with Chairman Garrett and support the goals of the draft the proposed Reg D changes. And in summary, I'd like to state it's absolutely critical that we continue to address regulatory impediments around capital formation and job creation, such as those addressed by the proposed legislation. Thank you again for the opportunity to participate this morning. I'd be happy to answer any questions.
And I thank the gentlelady. Next, Mr. Beatty from the state of Washington, as we've been told. Welcome, and you are recognized for 5 minutes. Thank you.
Thank you, Mr. Chairman. Good morning, Chairman Garrett, Ranking Member Maloney, and members of the subcommittee. My name is Bill Beatty. I am the director of the Washington State Securities Division, and for the past 28 years have served as an attorney in the division. I am also president-elect of the North American Securities Administrators Association, or NASA, the Association of State Securities Regulators. I have also served as chairman of NASA's Corporation Finance Section and as a member of the Special Committee on Small Business Capital Formation. I am honored to testify to you today about proposals to enhance capital formation for small and emerging growth companies. NASA has two mandates: promoting grassroots investor protection and promoting efficient capital formation. In fact, promoting capital formation is also a core mission of my securities department in Washington. We regularly meet with and assist small businesses to help them raise capital in our state. NASA shares Congress's goal to improve the economy by encouraging investment in small business. However, we believe this is best achieved through restoring investor confidence in the market. We want to bring investors back to the market, and we want to work with Congress to do so. My written testimony discusses how states protect retail investors, assist local businesses to raise capital, and oversee small offerings. At the outset today, I want to address an apparent theme running through many of the bills we will discuss today. This is the myth that federal preemption of state law is the most efficient and quickest way to promote capital formation. As many of you may recall, on September 13, 2011, NASA testified that states should play a leading role in establishing a new crowdfunding marketplace. Congress disagreed, and in April 2012 enacted a crowdfunding bill that broadly preempted state authority. At the time, NASA was already developing a model crowdfunding exemption. This model rule would have been adopted by the third quarter of 2012. When Congress preempted our authority in this area, our work on this model rule was deferred. Nevertheless, as I appear before you today, 7 states have adopted interstate crowdfunding exemptions, including my own state, and more than a dozen other states are considering similar exemptions. These actions decisively demonstrate that had Congress allowed the states to proceed, there could be a vibrant, functioning crowdfunding market today. Today we are discussing a draft bill that may once again preempt states from playing a key role in another emerging area that encourages capital formation for small local businesses, Regulation A+. During the Jobs Act debate, we urged Congress to preserve our role as the primary regulator of regulation offerings. Congress agreed, and NASA supported a GAO study of the factors that affected the use of Regulation A. We committed to address any factor that dealt with state blue sky laws. Consistent with our goal of capital formation and our pledge to Congress, we undertook a thorough self-assessment of our Regulation A processes and examined blue sky concerns addressed by the GAO. We also solicited public comments and consulted with numerous stakeholders, including the American Bar Association. The culmination of this effort is the NASA Coordinated Review Protocol, a modernized, efficient system for Regulation A review. Filings are made with one program coordinator and distributed to the other states participating. Only lead examiners communicate with the applicant. Our process is complete 21 business days after the initial filing, assuming no deficiencies in the application, and any delay in clearing an application is directly tied to the issuer's response time. Once lead examiners clear the application, the decision is binding on the other states. Our membership approved the new protocol, and as of today, 49 of 53 jurisdictions have implemented it by signing a memorandum of understanding. We are excited about its potential to help small businesses in our communities. In short, the states are ready to go with Regulation A+, provided Congress and the SEC don't short-circuit our efforts through preemption. You requested that we comment on 3 draft bills. We are concerned about the overarching deregulatory nature of these bills. As I've said, we wholeheartedly share your goal of assisting small businesses and spurring economic growth, but we believe that many of these bills move the goals in the opposite direction. Overregulation did not cause the collapse of our financial markets. America's capital markets are viewed as the gold standard because they are free, transparent, and responsibly regulated. This is the formula for economic growth and job creation. My detailed comments on these bills are included in my written testimony, along with suggestions for how they might be improved. Some members of this committee requested our comment on related bills discussed in an April 9th hearing, and my written testimony offers brief comments on those as well. In conclusion, state securities regulators share your goals, and we appreciate your interest in our perspective. My hope and NASA's hope is to work with Congress to pursue policy reforms that reflect smart regulation. Thank you. I will be happy to answer any questions you may have.
Thank you very much. Finally, last but not least, Mr. Lynn, CEO of Cedars Limited. Good morning. Welcome. And you're recognized for 5 minutes.
Good morning. Chairman Garrett, Ranking Member Maloney, honorable members of this subcommittee. My name is Jeff Lynn, and I'm the Chief Executive Officer and co-founder of Cedars. I want to thank you for inviting me to testify today in connection with the discussion draft of the Equity Crowdfunding Improvement Act of 2014, which I will refer to as the Improvement Act. By way of background, Cedars is one of the leading equity crowdfunding platforms in Europe. We launched in the United Kingdom in July 2012, and we opened to investors and entrepreneurs across Europe in November 2013. Since our launch, we have completed 92 financing rounds with a total of approximately £8.4 million or $14.1 million invested. We have financed businesses ranging from mobile app developers to theater productions to traditional manufacturers to financial services firms to a cheesemaker. CEDARS is authorized and regulated by the UK Financial Conduct Authority. When we received our authorization 2 years ago, to our knowledge, we were the first equity crowdfunding platform anywhere in the world to obtain regulatory approval. My own background is as a U.S. securities and corporate lawyer. I practiced with the international law firm of Sullivan and Cromwell in New York and London before founding CEDARS. CEDARS conducts its activities under the laws of the United Kingdom. I have detailed in my written testimony how UK law applies to equity crowdfunding, and in the interest of time, I will say here simply that there is general consensus that the British approach represents a reasonable and workable balance between investor protection and commercial viability, and that it is probably the best equity crowdfunding regime in the world today. Turning to the United States, Title III of the Jobs Act provides the legislative framework for an equity crowdfunding regime here. I have come before you today because I believe, based on the extensive experience I have gained in the equity crowdfunding space, that Title III as enacted is an unworkable law that will stifle equity crowdfunding in the United States before it ever begins. At the time that the legislation which turned into Title III was first being discussed and introduced by Congressman McHenry and Congresswoman Maloney, my team and I actively considered bringing CEDARS into the U.S. market. As Title III emerged into its final form in the Senate, however, we decided not to enter the U.S. because we did not think it would be possible to conduct a viable equity crowdfunding business under the regime. We would very much like to provide American entrepreneurs and investors with the opportunity to participate in this important and effective new form of finance, but we simply cannot do so under Title III as it now stands. There are, I believe, 5 core problems with Title III, and the Improvement Act goes a long way toward addressing each of them. I do not have time to address all 5 of these issues in detail here, and for my views on the fundraising cap, the financial statement requirements, the maximum amounts that investors can invest, and curation, I would respectfully ask you to refer to my written testimony. However, I do want to take this opportunity to address the final issue, which I believe is the most profound. Title III provides an exemption from the registration requirements of Section 5 of the Securities Act of 1933, but it does not address the equivalent provisions of the Investment Company Act of 1940. This means that while a platform may facilitate the direct issuance of shares by an issuer to investors under Title III, there is no scope for the platform to aggregate those investors into a special purpose vehicle or nominee structure. While this may seem a technical point at first glance, it is actually one of the most important issues in equity crowdfunding. If a small, growing company issues shares directly to hundreds of individual shareholders, that poses significant risks both for the issuer and for investors. Such a structure can kill a company by preventing it from raising additional capital or being sold, and it can deprive investors of the entirety of the appreciation to which they are entitled due to lack of critical contractual protections. The solution to this problem is the use of aggregation, allowing all investors to be grouped together in one SPV or nominee structure. The Improvement Act proposes to include aggregation structures used for crowdfunding under the list of exemptions in Section 3C of the Investment Company Act. I believe this is a hugely important provision and is essential to making equity crowdfunding work. To conclude, Mr. Chairman, equity crowdfunding has the potential to be a transformative tool for small businesses and for investors. If implemented correctly, it can create some of the most productive flows of capital an economy can ever see, bringing willing investors together to finance the businesses that will create the most jobs, wealth, and productivity. However, this cannot happen if the regulatory regime is not fit for purpose, which Title III simply is not. The Improvement Act makes significant strides in addressing the problems with Title III, and I believe that if this legislation is enacted in the form proposed, there is a substantially greater likelihood that equity crowdfunding will be able to flourish in the United States. Mr. Chairman and members of this subcommittee, thank you for the opportunity to appear before you today, and I would welcome the chance to respond to your questions or to amplify or clarify these statements at any time.
And I thank you, Mr. Lynn, and I thank the entire panel. And now we turn to questionings. So I recognize myself for 5 minutes. So I guess I'll start with Ms. Tierney. Some of you folks got into this a little bit, but maybe dig a little bit deeper for me. Reg D, can you run down, however you want to explain it, some of the most troublesome, some of the most burdensome aspects of complying with the additional reg requirements that SEC is proposing with regard to Reg D?
Of course.
Okay.
Second Market, as I noted at the beginning of my comments, is very active in the private company space, and we actually support a significant number of private companies raising capital under 506B and 506C. We know from our own experience as an issuer of an investment trust that's utilizing 506C that the facility to generally solicit has made it much simpler for us to get access to investors that we would not otherwise have access to. So we think that the rules as currently in place work really well, but the proposed rules, I can tell you from experience, have created a real overhang on the market for other companies that want to utilize 506C. And the most significant, I think, issues with the proposed rules, in my mind, are the multiple requirements to file Form Ds, an advanced Form D, the current Form D, a final Form D. An advanced Form D, as proposed currently 15 days in advance of filing, is completely unworkable for private companies. We raise money on a continuous basis. There's no start or stop. I think the proposed rules were really drafted for a Wall Street, investment opportunity model, not the way that private companies in Silicon Valley
there's got to be a start period, right, when you start doing it?
Well, my CEO, when we were a startup, was constantly raising capital. He could be at a cocktail party, and I'm sure you know this as well. You're at a conference, you're at anywhere in meetings every single day looking for investors in your offering. Okay. So it's continuous. To have to stop that for 15 full days and potentially trip it up is just unworkable. And I know that Nassau wrote a very good comment letter to the SEC noting, I think, Bill, you didn't support the 15-day advance filing. I think you came out at, if I recall, 2 to 3 days in advance. Is that right, Anya? But I know that the idea of any stop in capital raising is problematic for private companies. I think also the concept of having to file a final Form D, whether or not you've raised capital, can be a death knell for private companies. Nobody wants to go out and tell people that they failed to raise capital. That's not a good message to send if you're a startup. And Form Ds are difficult to file. You have to file one with the SEC, and you have to file one in every state where you actually sell securities. And I know the states are working very hard to get a uniform Form D filing system in place, but that doesn't exist right now. So can you just every state has a different approach to Form D.
Can you just go on what Mr. Beatty was talking about as far as what they're trying to do in this area? Is that a solution to the problem, or is the legislation a solution to the problem? Why is one better than the other, if it is, in your opinion?
I think that a concept of filing one Form D in a consistent manner that would apply to every state in which you sell would be a massive step forward for Reg D filings. But having to do 3 of those... Yeah, I get that. And having to file, I would assume, if the SEC adopts the proposed rules, that the states will follow and require that those additional forms be filed in every state as well. So that's expensive. I mean, we have to pay our outside counsel to file these Form Ds for us. So in other words, even if the states do what Mr. Beatty was talking about and come up with a sort of like a common multi-state arrangement is what you were suggesting there, that doesn't solve the problem, is what you're saying? I think it lessens the impact of the problem, but I think that my proposal and Second Market's proposal would be one Form D filing at the time that you commence capital raising. Okay. Not the 15-day after, not a final. So we would support one filing. I'd support a filing that had to be done at the state level if it's consistent and a one-stop shop kind of approach. So we took all this time on this one question. So what about the 1-year suspension that I'll let you start, then we'll get I think that is a death knell for private companies. Why is that? Because people make mistakes. And so say you file, if the rules were adopted as proposed, say you have a cease conversations for 15 days, but maybe your CEO says something by accident, and now you haven't filed your Form D 15 days in advance, or you forget to file your final. There's a lot of, these are small companies. They don't have expensive outside legal counsel. They're trying to do this themselves, and people make mistakes. The current requirements for Form D filings specifically state that the failure to file a Form D does not preclude you from relying on the exemption. To go from a structure where that is not a necessary item in order to comply with the requirement to you're out of the market for 12 months if you fail to file seems, I just don't understand how that's justifiable or how that helps the market. Gotcha. My time has expired, but thank you for the answers in those couple of questions.
The gentlelady from New York is recognized for 5 minutes.
Well, thank you to all of the panelists for your statements today. Mr. Beatty, during the time that we debated the passage of the Jobs Act, there was a great deal of debate over the state security laws and should they be exempted for offerings under Regulation A. And some people argued that the burdens of complying with state regulations was one of the reasons why companies didn't use Regulation A anymore. And as many of us recall, we reached a deal on the floor to remove most of the state preemption, although we allowed it in some circumstances. Can you describe the work that the state securities regulators have done since the Jobs Act was passed to streamline their compliance for Reg A plus offerings?
Thank you, Congresswoman Maloney. Yes, we've done a fair deal of work. Some of it was highlighted in my oral comments. What we have done, we recognized, I think, that with the GAO study that we could be better at doing these types of offerings. We could be more consistent. We could be more timely. We put in place a coordinated review system that, as I said, would result in the initial determination of clearance or need for additional work within 21 business days. This is something that we have signed an MOU on. We are committed to this. We believe this provides excellent service to the companies in our state and other states that want to raise capital. I think that what's been described here by Mr. Miller and the fact that he had jurisdictions that understood what he was trying to do is an important concept. We understand what companies are trying to do when they raise capital in our states. We want them to succeed. We think it's very important. The days of a regulator trying to find a way to deny offerings is just over. We don't do that. We need these companies in our state. The system that we propose is very timely. It is a one-stop filing, and it is a filing that will be made via email with our state initially. Eventually, it will go up on our electronic filing system that we are developing and will be available for Form D filings in November of this year. This is something that, given the timelines, and I would note at the back of my written testimony we have the timeline laid out in a table that I think is pretty easily understandable. But quick decisions, decisions that are based on one set of guidelines, this results in certainty, I think, for the filers and is a good thing for the filers and is a good thing for the states.
Well, can you discuss the areas where you think state security regulators can play a role that the SEC can't play? Is it mostly protecting the mom-and-pop retail investors or regulating small securities offerings?
Well, I think we do both.
What do you think you offer that the SEC does not offer?
Well, I think we do, as to the initial question, I think we do both. As I said, the mandate that I think most states have is protect investors and foster capital formation in our states. I think the role that we can play that the SEC doesn't play is that we are local and we are available. We understand that if somebody has a problem with an offering in our state, an investor, that the call is going to come to us, whether it's a federal offering or a state offering. It's not going to Washington, D.C. We also understand that from the standpoint of an issuer, if there is a problem and we are deemed to be intransigent or otherwise not responsive to an issuer, that we're going to hear about it not only from the issuer, but probably from our governor as well. So we're very responsive, and we understand the needs of these small companies.
Okay, Ms. Tierney, could you talk about your company's experience in verifying that investors are in fact accredited investors? There was a lot of debate over accredited investors when we debated this earlier. And do you think it's important to require verification that an investor is sophisticated or an accredited investor before selling them an unregistered security?
Well, apologize to Chairman Garrett for having to disagree on this point, but we do this for a business, so I have to be objective or not objective. We have done a verification, I think, on about 1,200 to 1,500 investors. mostly in the context of angel companies raising capital through 506c offerings. There's some points of friction in the existing rules that create problems. For example, they're drafted for U.S. investors and don't anticipate foreign investors who can't provide a credit report. So there are some frictions that the securities bar is working through right now. But I can tell you from our experience, people have been generally willing to provide the information. We try to be rational and reasonable. We are a registered broker-dealer, so people know that their information is going to be safe.
Well, very, very quickly, do you find that investors claim to be accredited investors when they are not? Do you have examples like that
we
you've
have
seen?
found that, Representative Maloney, we have found that people, not a large percentage, I'd say a very small percentage, of angel investors who had done multiple angel investments based on checking a box on an accreditation questionnaire, when having to provide actual documentation, weren't able to show that they had made $200,000. They weren't far off, but they weren't over the requisite threshold. But I'd say that the vast majority easily satisfy the rules. We have very few investors that come through that make $201,000 a year. So it's, but I know that a lot of investors that we're not seeing are saying that it's problematic to them to provide confidential personal information.
Right.
So I think there's arguments on both sides.
Thank you. Mr. Hurt, Vice Chairman of the committee, is recognized for 5 minutes.
Thank you, Mr. Chairman. Thank you all again for your appearance and testimony today. My question is for Mr. Miller and for Mr. Beatty. In talking about Reg A, I think the evidence is clear that historically only a limited number of issuers have taken advantage of the Reg A exemption for public offerings to access public markets. Mr. Miller and then Mr. Beatty, why do you think it is that issuers have avoided using the Reg A exemption in the past? And do you believe, what do you think the effect would be of raising the exemption per offering from $5 million to $10 million? What benefit would that give to small companies looking to raise capital? And then from Mr. Beatty's standpoint, what are the investor protection concerns that are posed, if any?
So, I think that the primary challenge with Regulation A is actually the speed. The first offering we did took us 9 months, and I had Melvin Myers, former general counsel of the SEC, actually leading the process with us. And that is, I mean, partly as a result of the fact that it's not frequently used. It's a very human process. People, the regulators aren't familiar with Regulation A. The regulators aren't familiar with real estate investment. And so you have a learning curve. And I do think that when you think about the process, the SEC spent 6 months, 9 months, 8 months in each one of our offerings. And I do sometimes wonder, I mean, SEC, I would say, sophisticated, knows what they're doing. To do it multiple times, I mean, we did it basically 4 times because each state is sovereign, although coordinated. And so there's a question of, you know, what is the additional, sort of basically repeating of the process, how does that benefit the investor? It doesn't necessarily benefit the fundraiser, even though the states are sophisticated in many cases. The other issue is that it's not just, I mean, everybody focuses on preemption, but there's other requirements state by state. In Maryland, we had to file as an exempt broker-dealer. Each state there's a lot of rules beyond the ones we're focused on that each state requires. And so it is a patchwork quilt. And the internet now makes it possible to raise nationally. So there's an efficiency that's possible nationally in order to get to scale that, I mean, I can imagine interfacing with we had hundreds of questions from the states, hundreds, about our offering. And if I were potentially getting questions from 50 state regulators, I can only imagine we would get more. So I think that the question is the SEC as a sophisticated body not sufficient? You know, I mean, why would I need to do it twice, essentially? That's the question I think that needs to be addressed in this Regulation A preemption issue.
Mr. Beatty? Thank you.
I think to answer your first question about why it wasn't, while Reg A was not was not used widely. I think it had to do partially with the offering amount. I think it had to do with, as Mr. Miller said, I think with the speed associated or lack of speed associated with the review of the offering, particularly at the federal level. I think that it was not used. It was not used widely, at least in our area, in multi-state offerings. Again, because it was not that large. Also, at least in our area with our local bar, there was a perception that essentially that perhaps because it wasn't used widely, that good companies didn't use Regulation A. And so they were reluctant to try and do a Regulation A offering. I don't know if that's pervasive throughout the country, but that's what our local bar told me when I asked them about it. As far as I would note that the system that we have put in place would address many of the concerns addressed by Mr. Miller in terms of inconsistent state comments and those types of things. As far as the investor protection element, I think what states bring to the table is that, particularly for local companies, we know these people, we know what the issues are going to be. We're familiar with these companies, and we're better able to perhaps address some of the questions. I see my time is running out, so I'll conclude my remarks there. Thank you.
And then I guess my question, just going back to Mr. Miller for a second. So the Jobs Act, of course, increases the cumulative Reg A offerings by an issue from $5 million to $50 million. Do you have a sense of what an appropriate threshold would be, and how would increasing that further would that aid small business?
Very briefly.
Yeah, absolutely. I think that you'll see small regional investment banks actually enter the space, Regulation A, and also start seeing real institutional block sales if Regulation A becomes available at larger amounts.
Thank you. Thank you, Mr. Chairman.
Gentleman is recognized.
Thank you very much. Thank you very much, Mr. Chairman. I said in my opening statement that we need to look at the big picture of this, and where there are regulatory impediments, we need to really examine it. And Ms. Turney, I really think you've hit on something here with the 506C and the Form D. And I do notice, Mr. Chairman, on our memo, we do have a mention of that, but we don't have any sponsorship on that. I don't know if that could be incorporated in that. But if so, I'd be delighted to work with you on that, because Ms. Tierney, I'd like for you to go just in a little more detail of exactly what we need to do, because I agree with you. If one form can do, and if these repeat forms of Form D is causing very difficult, a difficult obstacle to capital formation, then obviously we certainly need to address that, Mr. Chairman. I'd like to work with you on that. And with that, Ms. Tierney, can you just share with the committee what you actually would like to see us do succinctly?
I think that the absolute best outcome in my mind would be that every private company that's raising capital under 506 would file one Form D at the commencement of the offering to put the states on notice on whether they're using B or C, so that the states have the information they need to regulate fraudulent activity. Those forms would be filed one time, be available across all 50 states, say how much the intent was to raise, and potentially what the use of capital, the expected use of proceeds will be. But that would be it. And they would file that at the commencement of the offering, and then the states and the federal government would have the information they need. Right now, you have to file a Form D at the point in time that you sell your first. From the first time you have somebody invest, you have to file a Form D 15 days after the sale with the federal government, with the SEC. Then you have to file a Form D in every single state where you sell. Mm-hmm. So you may sell 1 week to somebody in Utah and the next week to somebody in Washington State. So you have to file a form in every single state the first time you sell. That doesn't seem sensible to me. I don't understand why that's beneficial to the states, to the SEC, or to investors.
And what does that cause the small business? What is the hardship there? Is there a cost?
It's the cost of preparation. Not every state it's a patchwork, as Ben and I have been saying, and I know the states are working hard to address that, but under the current regime, there are states that allow you to file a Form D electronically. There are states that require you to file it in hard copy. There are states that require a fee that's significant. There are states with a minor fee. There's a fee in every state, I would note. So this is a cash-generating business for the states.
Could you share with us what that fee might be, if you have that knowledge?
I'm so sorry, Representative. I don't know off the top of my head. I think it's as high as $2,000 in some states and as low as $100 in others. But you have to have, you really have to have either a registered broker-dealer or a law firm do this for you, or else you're going to get it wrong. And that, the implications for doing it wrong under the proposed rules are that you can't rely on Reg D 506 for an entire 12-month period, which for a startup means you're going to shut your doors and lay off all your employees. That's just the reality of it.
That is something very reasonable, I think, that we could really look at, Mr. Chairman. The other point I wanted to raise with you, Mr. Attorney, in your testimony, you mentioned safe harbor. Could you share with us what I was trying to follow you on that, but you were going very rapidly there. Tell us about the safe harbor.
Of course. And I'm sorry I talked so rapidly, but I only have 5 minutes and I was watching the clock.
It's more of mine not being able to keep up with you.
Okay. Thank you. So the way that the securities laws work around resales of private company stock under the current regime are there's a clear safe harbor under Section 4.1 of the 33 Act if you've held your common stock for 12 months. At the end of the 12-month period, you can sell into the market, you can sell to anyone, you can generally solicit, there's no restrictions whatsoever. That exemption, however, is only available to shareholders who've held the stock for 12 months, and it's not available to officers or directors, founders, or large angel investors who've made sizable investments in the company, so more than a 10% ownership stake. Then you have publicly registered securities where people can sell as they will on the NYSE or on NASDAQ. So you have, in between those two events, you have this delta of shareholders, employees. Most of us working for private companies get a significant amount of our compensation in the form of options.
And so tell us, how would you like to see this? What would be the best way of seeing this exemption applied?
So I think what it would be a transaction exemption for resales of securities for founders, angel investors, employees who hold options. When we were working with the community banks, it's the officers and directors of community banks. They're middle-income Americans who just happen to work for a private company. They couldn't sell their securities without worrying about the state law. And we've been working with NASA on this issue. They're very well aware of our position, and I think we all have the goal of making capital formation and job creation simpler. And I think having to deal with a patchwork of blue sky law every time you go to sell securities in this Delta shareholder group makes it extremely unworkable. And the implications are significant for private company shareholders.
Thank you very much.
Thank you. Gentleman yields back. Mr. Mulvaney.
With the permission of the Chairman, I'd like to yield my time to the gentleman from North Carolina.
Well, I certainly appreciate my colleague yielding. And Mr. Lynn, I want to talk to you about crowdfunding. As I stated in my opening statement, Carolyn Maloney and I worked diligently to make sure we had investor protection and the ability of folks to raise equity online. So you said that you viewed the law, before the regulations were written, you viewed the law as, quote, unworkable. Is that correct?
That's absolutely correct.
Okay, so describe to me what crowdfunding leaders around the world's view of the American crowdfunding equity law.
I think that my view represents the consensus view, both outside the United States and inside, that Title III, no matter how it had been implemented by the SEC, simply wasn't going to work. I know many of my colleagues in Europe have made the same decision that we have, not to look at the U.S. market as a result of it, and I know that many platforms in the United States that have relied solely on 506C or other forms of accredited investor-only rules had initially considered using Title III, but upon seeing its final form, decided not to do so.
Okay. So you mentioned also about the need for a special purpose vehicle, and explain how that actually lessens crowdfunding remorse, if you will, between investors and issuers.
Absolutely. So one of the often misunderstood but absolutely essential aspects of investing in a private company as opposed to a fully publicly traded company is that there are complexities around minority shareholder protections and other issues that get addressed by contract. So when an angel or a venture capitalist invests in a startup, they uniformly enter what's called either a shareholders agreement or a subscription agreement, which sets out a series of protections for investors. That works perfectly fine when there are 2, 3, 5, even 10 investors. When you have hundreds, though, the whole process falls apart, and you wind up with essentially the following scenario. No contract is entered into, the result of which is investors have effectively no protection against the various things that can happen to a minority shareholder in a privately held company, while at the same time the company is forced to deal with the administrative overhead and liabilities that come from having hundreds of direct shareholders, making it significantly less likely that later stage investors will want to deal with them.
Okay, so this idea of a special purpose vehicle is for investor protection?
It is absolutely for investor protection.
Now, the ability, the other question is for portals, the question of liability, sound liability provisions. I saw hundreds of comments about this with the SEC. Can you address that?
Well, I mean, I think that there are a number of issues around liability, the most important of which is that there needs to be a very, very clear delineation of where liability sits as between an issuer and a portal. You know, one of the very frank aspects that makes working in European markets advantageous over the United States in many aspects of securities law is the lack of strike suits and the lack of frivolous litigation. When you're dealing with very small businesses, that becomes even more profound. That can be minimized significantly by making very, very clear what actions and what omissions a platform or an issuer can be liable for.
This is twofold. So the portal, if they remove someone because they believe they're fraudsters, would they be subjected to liability under the current law?
Yes, sorry.
Okay, so if they remove someone, they perhaps could be sued, right?
Yes, sir.
So it's a twofold, both coming and going, the liability provisions, right?
It is, and that particular issue, which I've called curation, is one that comes up under the fact that portals are not allowed under the current law to provide investment advice, but that can very easily be construed and has been construed as preventing them from taking down businesses or refusing to deal with businesses that they feel may be fraudsters or otherwise inappropriate for their platforms.
Thank you for your comments. Mr. Miller, we view you as the lone wolf of Reg A offerings in the United States. How many Reg A offerings were there in the United States in the year 2010?
In 2010.
How about 2011?
I think that over the last 3 years, there's been approximately 19.
And how many of those are you responsible for?
Three of them, approximately 20%.
Okay. And what year were you the only Reg A offering in the United States?
I believe in 2012.
2012.
We were
okay. So prior to, I mean, but it's been basically viewed as a dead letter of the law. Is that correct?
Effectively.
Okay. Okay. So thank you for mentioning that, but I do want to mention that you are the lone wolf we view in terms of your boldness for this. So thank you, Mr. Chairman, and thank you.
I yield back the balance.
Thank you. Gentleman's recognized for 5 minutes.
Thank you, Mr. Chairman, and thank you to each of you for coming today. I just have a couple of really quick questions. Just following up on Mr. Scott's line of questioning about the need to file in multiple states. Mr. Beatty, I thought there was an effort going on by the North American Securities Administration Association to develop a kind of a one-stop filing process. Is that not accurate?
That is completely accurate, Congressman. The states have been working diligently to establish what we call an electronic Form D filing system. It is in development right now. It is scheduled to go live November of this year. It will allow one-stop filing. It will allow the payment of fees at one place. So I think the question about the concern about having to send paper filings to all 50 states will soon be a thing of the past. I'd also note that the Form D itself, it's an 8-page form. I think it has like 16 items on it. It's not a big form. I think I heard Anne Marie say that one filing at the commencement of the offering, and why the states maybe need to see the filing. These forms are incredibly important for us to see early on because we're the ones that get the questions from potential investors about, I got pitched this offering, and what do you know about it? And if we don't get the filing shortly before the offering starts, as we proposed in our comment letter, then what happens is we're forced to say something like, we don't have any record of this filing. You should be careful and ask a lot of questions. We don't know, quite frankly, whether the offering is a legitimate exercise by a company to try and raise capital privately, or God forbid, some scam artists out there trying to take somebody's money. So it's an incredibly important piece of information. It's a relatively small form, and we certainly would appreciate the opportunity to be viewed that.
You have a sense of what it is in this world we live in. It kind of amazing that we we wouldn't have that now. I mean, do you have a sense of what the timing of that is?
I'm not sure I completely follow you, but
the timing of the development of the one-stop.
Oh,
when will it happen?
November of this year it goes live. We've been working on it for a while, but November of this year it's scheduled to go live. It's on schedule to go live.
Okay.
So.
Let me use the remainder of my time to get any feedback from any of you. As you may know, I work with Mr. Fincher, who was here a few minutes ago. He's since left, on the IPO on-ramp part of the Jobs Act. And I don't know if any of you have had any experience with that, but I'd be interested in any comments that you might have about how the IPO on-ramp has worked in practice, whether you're aware of any intended or unintended consequences. We know that the data shows that IPOs are up quite a bit. Now, Mr. Fincher and I are taking full credit for that, and everybody else who supported, of course. Whether that's the reason, I'm sure there are lots of different reasons, but just any thoughts that anybody might have on that. And I guess, Mr. Beatty, if you think there are problems with that from your perspective. Ms. Tierney, I know you have some Blue Hen connections, so why don't we start with you?
I am a proud Blue Hen. We're not a public company, but we work with a lot of private companies that go public, and almost every single one of them is utilizing the IPO on-ramp bill in order to facilitate becoming a public company.
Any feedback about which provision in particular has been most helpful?
Again, not having my own experience, but I think the ability to file confidentially is a huge benefit to private companies.
I've heard that from a lot of people.
Yeah,
there was a lot of, and by the way, there was a lot of difference of opinion on that particular aspect of it, but that's the one thing that keeps coming back that's been really helpful. You're shaking your head. Would you like to share some thoughts as well?
There's no doubt that's true. I've heard that from, I work with also some public real estate companies and small public real estate investment trusts. And across the board, to be able to file confidentially, you can withdraw without basically having a punitive result in the market. It's very, very material to the consideration of going to the public markets.
Great. Mr. Beatty, any comments from the other side? Maybe that
I would agree with my co-panelists about the feature, the confidentiality feature. That is the one that I hear about the most as well. I think from a regulatory standpoint, we have some concerns, not just with that particular feature, but the trend for less transparency in the markets. We believe that, as mentioned in my opening remarks, that the transparency is an important feature for our public markets, and it's just one of the several things that we've seen that have kind of decreased that transparency. How that will play out, I mean, we certainly haven't gotten any complaints about it or anything like that, but how that will play out long term does give me some concern.
Right. Well, thank you all very much for what you do, and thanks for being here today.
Gentleman yields back. The gentleman from Texas is here.
Thank you, Mr. Chairman, for holding this important hearing. Mr. Lynn, basically, what I heard you saying is basically with Title III the way it is now, that the crowdfunding is difficult, and I think you used the word almost impossible.
Impossible is the word I would use, sir.
And so the question is a lot of times we have good ideas that we get really from the private sector, and we massage them up here, and we try to codify them, and then we send them over to the executive branch, and the executive branch massage them, and when they come out the other end, they don't always end up being like, we thought they were going to be. So I think one of the questions I wanted to ask you is, when it comes to that section, was the structure of the law flawed, or was the rules, are the rules the problem, or is it a little of both?
I believe it was primarily the structure of the law in the form adopted by the Senate. While the version adopted initially by the House, I think has been improved upon by Congressman McHenry's proposed draft, the core structure was there. By the time it came out of the Senate and went to committee, I think that was where the main failure was. The SEC rules could not have then saved it, no matter what they said.
And so basically, what you think it's going to take a legislative fix and not necessarily an administrative fix?
I think that's absolutely the case, and I can tell you, sir, that I've spoken with a number of staff members at the SEC who have, on an off-the-record or non-attribution basis at least, acknowledged that they felt their hands were tied in trying to address many of the concerns because the legislation was written the way it was.
What would you say are the one or two most burdensome pieces of that really would impact that?
I think if I can identify the three top ones, it's the levels, the thresholds for financial statements. I mean, financial statements are something of a red herring when you're dealing with very early stage businesses. They don't say anything because the company hasn't done anything yet. And requiring an audit or even an accountant review for very, very small businesses is hugely disproportionate and simply makes it impossible or virtually impossible for businesses to rely on. I think the issue I addressed in Mr. McHenry's question regarding curation and the inability to select which businesses go on the platform in a subjective way is a huge flaw, and the points around the lack of ability to use an SPV or nominee structure is the third.
One of the things that I understand in the proposed rule is that, for example, if you own 20% of the company, that you are subject to a look back of 3 years of your personal tax returns. Is that necessary? And does that, if I'm part of a startup, and does that keep me from participating?
I think it is one of a number of perhaps secondary level burdens that is unnecessary. I think it is an example of the type of rule that was designed with much larger publicly traded companies in mind. It simply does not apply or does not have a whole lot of utility when you're dealing with a two-man in a garage startup.
And Mr. Miller, I was amused by your comment about the legal fees that small businesses are having to pay in order to come into compliance. Is that just because there's so much risk out there of if you don't comply with if you don't check all of the boxes? Is it the complexity, or is it what do you think is driving most of that?
I think it's primarily driven by complexity. I mean, this is you can be a software engineer or a bioscientist, but the regulatory knowledge to make sure that you maintain compliance, and in particular, if you want to grow, the compliance is critical to your next round, right? If you raise $500,000 and you violate securities law, your business is dead, even if it's successful in underlying merits. So the complexity is outside the knowledge base of a normal entrepreneur, and so you have to rely on legal counsel, and that basically, the complexity of the law and the number of regulators involved drives the amount of legal fees.
One of the things we hear from people all across the broad spectrum now about in their businesses is the term regulatory risk, that whether it's compliance or other areas of government, that one of the things that's really stifling a lot of businesses is regulatory risk that's out there, and how to price it into your product. Does anybody disagree that there's regulatory risk that has increased over the last few years?
I would completely agree. I mean, for a long period of my career, I was involved in taking companies public in the United States. This is the first job I've had where I worked for a private company and working with private companies. And in the time that I've been a securities lawyer, the scales have tipped. There are not a lot of good reasons to be public companies in the United States of America right now when you do a cost-benefit analysis around the risk, the costs, and the burdens of being a public company. There are a lot of good reasons to go public that will always be there, but I think for a lot of private companies, with the facility now offered with a 2,000 registration threshold and the ability to more easily, raise capital under Reg D, under 506, they're really going to be deferring those IPOs for a very long time, and I think that's the right regime. But it's sad to me as a, former SEC attorney and an NYC attorney to see companies not want to go public.
Thank you.
We're going to have to cut it there, and we'll have, I think, our last word on it. Mr. Gildy, you recognize 5 minutes.
Thank you, Mr. Chairman. I'll be brief. I was talking to Mr. Carney, and I just want to say I don't know what a blue hen is, except that I know that I've never been served one. I assume that they're very good.
You're missing out.
If my question, and I'll just have one question. If it's redundant, if it's already been asked, I apologize for that. But I'd just like to follow up on some of the comments that I made in part one of the hearing that was held earlier this month, that while these proposals ostensibly are intended to increase for capital formation for small and emerging companies, we've yet to fully realize the impact of the Jobs Act. Trends in the future may prove that there are some shortcomings in the Jobs Act for which a cohesive legislative fix might be required, but now the House would have to address this with a legislative solution. Specifically, though, I'm interested in the areas of capital formation. It seems like, to me anyway, the mortgage market and ensuring that people have the ability to purchase a home might be a better place to start this conversation. And if we're looking to have additional sources of capital for small and emerging companies, we might focus on reauthorization of the Ex-Im Bank, which I know in my state has been a really significant player in helping to get small companies moving and reach additional markets. But my main concern with these proposals and the ones from today and earlier this month is that they specifically, in some cases, preempt state regulator oversight. And specifically, just the other day we had SEC Chair White here, and we had, I think, a good exchange. But one of the questions that I posed to her and that I'm concerned about is that we have the SEC that's already fairly thinly stretched, and with increasing obligations continuing, we could have a debate about whether those obligations are appropriate. And we have had a substantial debate on that subject. But I don't think we should try to dial back on whether the regulations in place should be enforced by limiting the resources. But I'm concerned about the sort of combined effect of reducing state regulatory responsibility or roles in this particular space, while we have an SEC that seems already challenged in meeting its obligations. So I don't know if, starting with Mr. Beatty, I'd certainly want to get your observations, but if the rest of you could also make comment, I would certainly appreciate it. And that would be the only question I would have today.
I share similar concerns. I note that there was a recent BNA article that talked about Regulation A+, and it noted that I'm sure I've got the number wrong, but the average review time for a Reg A offering before the SEC was something in the over 100 days anyway. We're proposing with our Reg A coordinated review proposal to have an initial decision back to the issuer within 21 business days. So I think we share your concern about diminishing resources. A strong and healthy SEC is important, but we also think that we have something to bring to the table, and this is not the time to take regulators off the table in terms of providing services.
We've proposed to the SEC that for the offerings below $5 million, that they actually would leave it to the states rather than having requiring the SEC and the states for an offering that's less than $5 million under Regulation A. So, and as a proposal, it would lessen the burdens on the SEC while giving the states a purview to succeed inside, I think, what would be more likely a smaller local offering of less than $5 million.
I think if I could just take a slightly different view, I have no doubt that in many ways individual state regulators may be more efficient or more effective than the SEC. The problem is that the majority of offerings, particularly, I appreciate real estate may be a bit different, but particularly for small and growing businesses, the fact that they're small does not correlate with them being local. They tend to have internet-based offerings, supporters, and people who want to invest in them from across the country and often internationally. And I think that the more barriers you put up and the more differentials you put up across borders, the more difficult that becomes. Whether the locus of regulation sits in one or the other, I think, is less the important question than whether we're dealing with potentially 50 different, slightly altered regulatory regimes versus a unified one. And I think that if we get into that situation, that's the real problem.
And having had the last word, Mr. Lynn, I thank you, and I thank the entire panel for all your very good testimony. It was very, very helpful, both your written testimony and the testimony today. Thank the members of the committee. Without objection, all members will have 5 legislative days to submit extraneous material to be included in the record. Also, within 5 legislative days, all members have the opportunity to submit additional questions to the chair, which would be then submitted to the members of the panel, and then we would ask for you to, if we do get more questions, to promptly respond to those questions in kind. With that, again, I thank the panel and wish you a good day. And this meeting is called adjourned.